Property Disclosures, The Real Estate Professional's Guide to Reducing Risk, page 32, Chapter 3 continued. EPA cites building owners for 46 violations of lead-based paint rules. In 2002, the U.S. Environmental Protection Agency, Region 5, filed a 46-count complaint against apartment building owners I and J for allegedly failing to warn their tenants that their homes may contain lead-based paint hazards. The properties are managed by a realty company in the Hyde Park area of Chicago. A penalty of $76,890 was imposed. EPA and HUD cooperated in the investigation and development of this case and others. The complaint cites I and J, owners of multiple properties, for 46 violations in 10 apartments. Thomas Skinner, administrator of EPA Region 5, noted that by carrying out these enforcement actions, EPA is reinstating that protecting children's health from lead-based paint exposure is one of our highest priorities. To this end, we will vigorously pursue compliance with this rule. According to the Chicago Department of Public Health, more than 12,000 children younger than 6 were diagnosed with lead poisoning in 2001. Large settlements in property management. A jury awarded a 13-year-old girl $5,355,000 who alleged that exposure to lead-based paint in an apartment caused permanent cognitive defects, hyperactivity, and diminished IQ. Badia versus Joyce Realty, number 169-84191, New York, Sup, CT Kings County, August 1999. She contended that the landlord negligently allowed a dangerous condition to exist. The landlord denied liability. In settlement discussions, the plaintiff demanded $650,000, but the landlord's highest offer was $350,000. The plaintiff presented testimony from a pediatric neurologist and an economist to help establish her damages. The jury's verdict was broken down as follows. Future medical expenses, $1 million. Future wage loss, $2 million. Pain and suffering, $1.8 million. Other unspecified damages, $555,000. Total $355,000. A mother and child awarded $1.3 million alleged that lead poisoning during the child's first 3 years caused brain damage, including hyperactivity, learning disabilities, and memory problems. The amount of the award was reduced on appeal to $555,000. Giraldo versus Khan, 267 AD 2D 205 699, New York S 2D 456 1999. Experts testified that the injuries were permanent and his prognosis was poor. Even though the child had relatively average intelligence and might be able to participate in special remedial programs. On appeal, the defendants contested both liability and the amount of damages. The trial court instructed the jury that a statutory presumption existed that if a building with multiple dwelling units had been built before 1960 and a child younger than 6 lived in the building, peeling paint would be deemed a hazardous lead condition. The appellate court agreed, noting that there was sufficient evidence from which the jury could conclude that the landlords knew a young child lived in the building. However, the court agreed with the page 33 defendants' assertion that the damages for pain and suffering and lost services were too high and ordered the parties to agree to reduce damages of $555,000 or have a new trial on damages. Case study. Upon the advice of their listing agent, the Smiths hired a company to perform a lead-based paint analysis on the property. Lead-based paint was discovered in the home. The sellers completed the lead-based paint disclosure form, but did not attach a copy of the report as required by law, nor did they give a copy of the report to their listing agent. The Browns signed a purchase agreement on the property later that spring. The sellers orally advised the buyers of the presence of the lead-based paint, but the report was not given to the buyers until closing. The buyers eventually filed a lawsuit against both the sellers and listing agent for violation of the Federal Residential Lead-Based Paint Hazard Reduction Act. Number 1, what should the listing agent